Good morning, everyone. Good morning from cold, rainy Lublin in Poland. I would like to warmly welcome all the participants of today's lecture. First of all our international partners with whom we have excellent cooperation, also academic staff, students, and everyone joining us today. It's a great honor for me to deliver this lecture and to, of course, to represent our university, WSEI University in Lublin. Today's lecture is connected with the virtual mobility of our university, which is one of the many international activities, really many international activities. So at the very beginning, I invite you to visit our website, wsei.pl, where we also inform about our other projects. My name is Łukasz Wojciechowski. I'm an academic researcher, teacher, currently holding the position of university professor at WSEI University. I work in the Faculty of Administration and Social Sciences and also in the Institute of Public Administration and Business. I am also an experienced entrepreneur, specializing for many years in personal data protection, especially in the practical application of GDPR. So I will try to make this lecture interesting and practical. On May 25, 2025, but I personally don't believe in numerology, we will mark the 7th anniversary of the General Data Protection Regulation, which is called GDPR, RODO in Polish language, coming into force. However, in Poland, that date will be between the first and the second round of presidential election, so many people might not even notice this anniversary. Back in 2018, when the GDPR started to apply, people in Poland were mostly afraid of financial penalties imposed by the supervisory authority, which is in Poland the president of the Personal Data Protection Office. But now we are much more experienced, and now we can talk about many different aspects of GDPR. I will start with key definitions because, in my opinion, the most important thing is to recognize whether we face personal data or not in each situation, in our workplaces, in all the projects, because sometimes we meet personal data and we do have to follow GDPR rules, and sometimes we do not face personal data, which means that we also need to protect personal data, not personal data, but just data. We have to protect the data, but we have to do it in a different way, using different regulations and different legal provisions. Our lecture will last about 1 hour, and after that you can ask questions. We can connect with cameras and microphones. You can also use the chat on the right down corner. And if you don't want to do it today, but you would like to cooperate with me and our university, our institute, I will also show you my email address, give you my email address, and we can contact like this. So first hour, you can relax and just listen to me, and then it will be possible to ask the questions. Coming back to key definitions, as I told you before, the most important task is to recognize if we do have personal data or not. What does it mean, personal data? What is the definition of personal data? So definition in Article 4 of GDPR is that if we think about personal data, any information relating to identified or identifiable natural person. It doesn't matter if we have name and surname, address, or some specific data, but when we know that Okay, using such information, we know that this is Łukasz Wojciechowski, this is John Smith or anyone else. We can say that this is personal data, and now we have to start to follow GDPR provisions, all the rules which are in GDPR legal act. And we have typical everyday personal data, but we have also a kind of sensitive data, which is called special categories of personal data. It means that we have to protect all the information which are personal data, but unfortunately we have to concentrate on sensitive data, and we have to remember that this is a special kind of data. This is connected with our private life, with, for example, with our health, with our racial or ethnic origin, political opinions, also, for example, sexual orientation. This is a kind of data that we know personally about us. Sometimes we would like to talk about it with our friends, our family, our parents, our partners, but we don't want to talk about it with all the people in the world. So this is a kind of data which is very, very private, really connected with our private life. The next definition is data processing. Data processing means any operation or set of operations performed on personal data. And my experiences from Poland are connected with trying to avoiding using GDPR provisions. Some data controllers said we do not process personal data because we do not take any new actions connected with such data. We just collected it in the past, and now we don't use it anymore. But it's not true. If you have personal data in your company, in your workplace, it means that you do process it, and you have to follow GDPR rules. And the second important task connected with data processing is that you have to protect it when you start processing personal data. So at the very beginning, when you collect it, for example, and you use it at the first time. But on the other hand, when you think about, for example, deleting personal data, you also have to protect it, because this is also data processing. So all the tasks connected with processing personal data is processing in the meaning of Article 4 of GDPR. And a very difficult definition. In some European Union countries, it's not such difficult definition as in Poland. In Poland, we have many problems with data controllers, with recognizing data controllers. This is because there are some, for example, public institutions in which we have their presidents, their heads. We have also institutions. We have some other elements of such institutions, and it's hard to recognize whether the mayor of this town is a data controller, or maybe the whole self-territorial government, or maybe a part of it. And we have to compare and contrast our internal regulations with other similar institutions, I would say, to recognize the data controller. And you can also see that data controller can be natural person also, but it's not very popular. Sometimes we become entrepreneurs after being just a typical person in the internet. When we, for example, create a content, we become entrepreneurs because we start to get some money because of the fact that we do it, and we become data controllers. But it's it's not everyday situation. It's only sometimes. And if you understand key definitions, and you can recognize if you meet personal data in each situation, this is a very good beginning, a very good start to think about other roles and other aspects of processing personal data. And also, this is a good beginning if you think about protecting data which is not personal data, because sometimes we have some pieces of information which are extremely important, key information for our company, like some secrets, for example, like know-hows, for example, but this is not personal data, so you protect it, but you don't use GDPR rules. In some parts of GDPR, we have extremely important procedures, extremely important provisions, and sometimes we forget how important they are. Some people say, okay, GDPR is not very clear, we don't know what to do to protect personal data, but I always ask such people to just to read Article 5, which is extremely important. It is really clear, and sometimes it's surprised. For example, in Polish public institutions, people are really surprised when they see what are the expectations of GDPR creators, what are the main rules. For example, it is shocked that they have to process personal data in the short period of time. They have to process personal data and think if it is really necessary. They can't collect personal data if it is not extremely important to take some actions and to do some important tasks. But let's start with the beginning. So the first rule that maybe I will use, just a second. Okay, I will use the pen. It will be easier. The first rule is that personal data must be processed lawfully, fairly, and transparently. So in GDPR, we see that in European Union, we have to think about all the people, the whole society, I would say, people who know legal provisions, who know how to read the law, how to read the legal acts, but also people who are not very experienced, who are not so well educated, who are, for example, children, and they also have some rights, and they also have the right to understand what's going on when we think about processing personal data. So it means that this is transparently processing, but also it is connected with giving very easy information, I would say, easy to understand for such people, for showing them the rules in the easiest possible way, which means that they will understand it, they would understand it. What's more, it is also said that personal data must be collected for specified, explicit, and legitimate purposes. It means that if we do not have the legal provision and someone didn't permit to process his or her data, we can't do it. We can't start processing personal data. It's illegal. It's against European Union law. But it is also said that if we collect the data for one aim, one purpose, we can't use it for different ones. Sometimes, for example, in some companies, the owners would like to use the personal data which was collected for example, some financial aspects, some financial procedures, because they had to just create the invoice, for example, and they would like to use it for marketing reasons. They want to advertise, for example, their products using email addresses. It's also illegal. They can't do it. If they want to use the email addresses for advertising, they would have to ask natural persons if they agree or disagree for that. What's more, also personal data must be adequate, relevant, limited to what is necessary. As I told you, we can't collect information which are not necessary to take specific action to do some specific tasks. And also personal data must be accurate and kept up to date, so we have to take care. We have to remember that we have to sometimes refresh, I would say, personal data, make it up to date, and make it accurate when we think about the people who are connected with such data. Also kept in a form which permits identification of data subjects for no longer than necessary. So it is important to delete personal data after, for example, 2 years or 3 years, when we don't use it anymore and when we don't need it. Because collecting data just to do it, just to collect, is also illegal. And the last thing, personal data must be processed in a manner that ensures appropriate security. So we have to think about security in many aspects. I will tell you about it in a minute. If you go through principles of data protection in Article 5 of GDPR, you can think about ICO 2701 the whole theoretical aspects of information security, because we have 3 parts of information security, not only personal data security, but also information which is not personal data. And we have 3 aspects of it. So this is confidentiality, this is integrity, and availability. And if we go through Article 5, you can find such elements in many different rules. So this is connected with information security and these 3 elements. But the creators of GDPR, I call them the creators of GDPR, they decided not to use it one by one, but they changed a little bit and it looks a little bit different. And we have, of course, principles of personal data processing which are extremely important, but we also have legal grounds for processing. Many people in Poland think that the only way of processing personal data means that someone have to agree for that. I mean consent of the data subject. If we have consent of the data subject, we can process personal data. Of course, it's true, but this is not the only way. And I also tell the students and people who take part in my trainings that consent is the worst way for data processing. If you think, okay, why this is the worst way, maybe it's the easiest way because we just ask someone and he or she agrees. But remember that people can just change their decisions, and they can say, okay, you had the consent, now you don't have the consent. I agreed, but now I disagree. And you have the problem because you don't have legal ground to process my personal data. So if you use different legal ground, you do not use consent, it's much more easy because it's not so easy for people to change their decision, I would say. And please remember about it and try to avoid consent if you don't have to do it. However, don't worry, because we have many different legal grounds. Consent is dangerous, unfortunately, but on the other hand, we can use many different legal grounds, and they are very useful, and we can use them in many different situations. First of all, this is performance of a contract. If we sign a contract, this is also the legal grant of processing personal data without consent, without someone's permission, because if he or she signed the contract, or we are just preparing to sign the contract, we take some actions before signing the contract, it means that we can process personal data in a legal way. Of course, we have also compliance with a legal obligation and performance of a task carried out in the public interest or in the exercise of official authority. If we imagine that, for example, a police officer stops our car because we were driving too fast, it would be very stupid that if that police officer would ask us if we agree, if we give him or her the consent to process our personal data, and if we do not agree, he or she can't do anything, and we can drive our car with the same fast way. It would be very inappropriate. So of course, sometimes official authorities, police officers, civil servants and other people can process our personal data without the consent, but they need legal provisions. So if in some legal acts there is a provision that someone can process our personal data, we do not have to give a consent. It is connected with just legal provision. But we also have something which is called protection of vital interests. And it means that sometimes we do not have to ask about permission. We don't have to think about the consent, because this is the very I would say unusual situation, for example, connected with some health problems of natural person. Sometimes people can't give us permission because they really need some, for example, medical help, and we also can process personal data. But sometimes we can use this rule not only in the situation connected with health. For example, when we find something important to natural person, for example, the wallet. If we find the wallet, I think that if we have personal data of a person, of the owner in our workplace, we can use it and contact such person, because calling someone with the information that we have someone's wallet would be really important for such person, would help such person to not to spend a lot of time and a lot of money in banks and also different institutions, for example, to create new documents or credit cards, etc. So we can think about this rule in such situation. And the last legal grant for data processing we call a legitimate interest pursued by the controller or a third party. In Poland and in some other European Union countries, we had some troubles with this legal grant because of the fact that in many companies, the owners thought, okay, we can use this legal provision and we can do whatever we want, for example, to advertise our products, because we don't have to worry. We have the legal provision, which is this last one that you can see here. And it's not true, because it doesn't work in all the situations, and in many cases the owners of the companies have to check if it works or not using professional procedures, which is also quite difficult, and also they need the special knowledge, they have to be experienced to recognize such situations. So it doesn't mean that you can do whatever you want because you have the special interest in it, in your opinion. So to sum up, legal grants, remember that you can use the consent, but it's not a good idea if you have other legal grants. If you use other legal grants, the most comfortable situation is that you have the legal provision and you can do it, and it is very comfortable for public institutions, but because they do have legal provisions in many situations, because they work using legal provisions, and they work to settle some matters, some people matters. So they do have legal provisions, but it's very difficult when we think about public, not public, but just companies, because they don't have. Sorry, I will just turn off my mobile phone because it disturbs us in the lecture. In companies, they have to think about the consent or some different legal grant, but it's quite difficult. So processing personal data in public institution is easier than in the private company. Okay, let's talk about safeguards. This is quite important part of GDPR, but in GDPR it is not shown in a very precise way. Unfortunately, we don't have many rules. We don't have many, I would say, tips how to do it. They just give us general information. Sometimes we have to think about technical of other safeguards in our companies or institutions. We have to think about it individually. We have to ask some experts, because they don't show us many solutions. Unfortunately, because, for example, in Poland, we have, before GDPR, we had some legal provisions in which it was really precise, said what to do. And it was very clear what to do to protect personal data, if we think about technical aspects, but also other aspects. Okay, let's go through technical safeguards. So what are the examples of technical measures? First of all, it's encryption of data. for me, I find it quite interesting that encryption of personal data becomes more and more popular in, for example, public institutions in Poland. In the past, it was too difficult, I think, but now they are trying to find the solutions for them. Of course, this is a good idea, but we still have a lot to do. It is also used in private companies, but not very often. I think that if we find good applications, good ways how to do it, it will be easier and when it will be cheaper, I think. But this is also connected with technical aspects. If we have good computers, we can say fast computers, it's easier to do it and to avoid some problems during our work, everyday work. What's more, use of secure passwords and authentication methods. Some specialists say that passwords are not as important as we think, because in Poland, when we start some cybersecurity trainings, for example, and when we start talking about safeguards, we very often start talking about passwords and what does it mean to create a good password, and how many letters, how many special signs, how many numbers inside such password. And I would say, okay, it is quite important, but we also have to think about some other authentication methods, because if we use them, sometimes if we lose our password, it's not so important if we use other methods. For example, if we get the special code by SMS to our mobile phones, or we use special tokens or different things. So in my opinion, if we think about GDPR in 2025, it is important to say, okay, good password is important, strong password is important, but it can't be the only way to protect our, for example, email account, or what's more, to protect our, for example, bank account. What's more, regular software updates and patches. Many people forget that if we forget about software updates, it means that we just help cyber criminals to do their job, unfortunately, because our computers, our different devices are just open to cooperate with them. Sometimes the very good way to protect personal data is just to check all our devices if we have the updates. If we, for example, didn't click that or tick that we don't want updates because we didn't have enough time, we were afraid that our computer would work slower. So if we did it in the past, we have to think about updating software as fast as it's possible. And also data backups and disaster recovery procedures. In some European Union countries, it is still not very popular to create data backups. This is because it takes some time, and sometimes it's irritating that we have to do it. But remember that if we have data backups, it means that we are really safe. If we think, for example, about ransomware attacks, which are extremely popular in all European Union countries, cyber criminals are trying to block our computer systems, and they just send us the message, okay, if you would like to use it, you have to pay for me, and it's a kind of ransom. This is because it is called ransomware. So if we have data backups, we can just forget about paying them. We can just forget about ransom. We just have to delete all the data from our device and do the backup and work as in the past. So it is very important also to use the tools of data backups, which are safe, and our data is in a different place than our computer. If we copy something and have it in the same place, use it in the same place or same virtual place. If we have the cyber attack, we can't avoid ransomware also in our backup. So please remember about it. And this is the first group. The first group is technical safeguards, but we have also the second group. And honestly, when I think about my customers, companies with which I cooperate and help them in GDPR aspects. If we talk about technical safeguards, they are not very clear in GDPR, but if we talk about it, they know what to do, they feel what is the meaning of technical safeguards, and sometimes they completely don't know what are organizational safeguards. It's really hard to understand what to do, and GDPR is not, how to say it in polite way, it's not really clear. And when we think about organizational safeguards, because it is very often said that we use technical and organizational safeguards, but it is not said what does it exactly mean. So some examples: organizational measures include, first of all, internal policies on data protection. If I tell some people during trainings that organizational safeguards are internal policies on data protection, they're really surprised, and they think that maybe it's a kind of joke because it's so simple, but it really is. International policies. When we think about internal procedures, we also check them, we also make them up to date. So we update them, for example, once a year. It really helps, and remember that internal procedures connected with GDPR should be short and should be possible to understand for all the employees in our workplaces. Because if we have really long procedures, for example, in some companies, I saw procedures which were 100 pages. I just asked them, okay, who is going to read it, and who is going to follow such procedures? And this is the key. This is the problem. So it should be short and easy to understand for all the people. And then there is because if we have 100 pages, there is a slim chance that someone would use it. If it's 10 pages, so it's much more probable. So please remember about it. It can be short, and then it's easier. Okay, what's more? Staff training and awareness. Of course, if we think about human resources, we have to think about their knowledge, about their experiences of personal data protection. Sometimes when I come to public institutions, but also companies, and I ask some employees about GDPR, they just say, "Oh, no, we have DPOs, we have our boss, they are responsible for GDPR, we know nothing about GDPR." And this is a very huge mistake, because all the people should understand the main rules, I would say, something that I was showing before, and this is the only way that GDPR can help to protect personal data in our company or in public institution, in our work places. Also, access control and segregation of duties, I think that it's clear, and also regular audits and risk assessments. All the GDPR rules are collected with risk assessment, and we have to do it. But it's a subject for a different lecture. Maybe in the future we will talk about it. We have something new connected with GDPR. Now it is not so novel, because we have 7 years experiences of the GDPR, but it was something really new, and a kind of game changer, I would say. And if we think about personal data protection, this is reporting data breaches. It means that if something wrong happens with personal data, we have to tell about it. We have to tell the supervisory institution. So we have to just report it, that something wrong happened, to supervisory authority. This is a really important change, because in the past, before GDPR in Poland, we had to report all the data sets in each public institutions and in all companies to supervisory authority. So it was, sorry, I know that it's impolite, but it was extremely stupid, because in our supervisory authority, they didn't have enough employees to just process all the information which came from companies and public institutions. It was difficult for them to create such data set of data sets. So it was really difficult to do it. It wasn't a very good idea. But now we just report breaches. So we just report our mistakes or situations that we didn't expect it. We have 72 hours to report it to our supervisory authority, and after that they can ask us about something. Sometimes we have to write something to our authority. Sometimes we have to explain what happened, but it really helps to worry about personal data protection, and to think about personal data protection, because if we do not report it, we can have some troubles, because we do not follow some GDPR rules. If there is a high risk to the rights and freedom of natural persons, of individuals, we also have to report it to such people. Sometimes you get the information that something wrong happened with your personal data from some companies or public institutions, and this is it. So this is the situation when there is a data breach, and also there is high risk to the rights and freedoms of you. That's why you get some information, and you can prepare, for example, to avoid some actions of cyber criminals. And if you think about common types of breaches, we have many different types of them. I think that the most popular data breach in Poland is sending personal data to the wrong person. It's very popular, but we have many other examples. Also, if we are the victims of cyber attacks, we also have to report it, and this is also a kind of breach. Unfortunately, because we didn't want it, and we didn't do anything wrong. Sometimes we forgot about safeguards that we were talking about 5 minutes ago. Okay, and in the last part of today's lecture, I would like to tell you a little bit about data protection officers, DPOs. In Poland, we had many troubles with DPOs when we think about the time 7 years ago, so the year 2018. Why? Because of the fact that we didn't have enough people with appropriate knowledge, with enough experiences, I would say, who can do this job, who can be data protection officers. And in our university, in WSEI University, we run the postgraduate, the name of this is postgraduate studies for DPOs. Now we have the 7th edition. So as you can see, this 7 years of GDPR and also the 7th edition. So every year we have a group of people who learn how to be DPOs, and they are really well prepared. And also in other universities in Poland and in some other places, we have the special trainings for DPOs. So now, after 7 years, the situation is much better. But in the past, it was really difficult to find good candidates, I would say, people who are experienced enough, and they have the special knowledge about how to protect personal data. But let's start with the beginning. So first of all, the next game changer, I would say, was that in all public authorities or bodies, in all public institutions, we have to appoint data protection officers. We need them in all the public institutions, because it is connected with legal conditions. So, for example, the head of school, the mayor of the city, or different self-territorial government institution, they do not decide whether they will employ data protection officers. They have to do it because this is connected with GDPR. And there are two other conditions in which we have to obligatory have such person in our not public institution but company. First of all, the core activities require regular and systematic monitoring of data subjects on a large scale, and the other thing is the core activities consist of large-scale processing of special categories of data. It means that if we have not just some pieces of special categories of data, but we have a lot of special categories of data. You remember the beginning of the lecture, I was talking about special categories of data. We have to appoint data protection officer, which means that we need to find such person, and we need his or her in our company. We also have to report to our supervisory authority in Poland. It's president of the Personal Data Protection Office. We have to report that we found such person, that for example, Mr. John Smith will be our DPO, and they check if it's true or not. But and this is one aspect which is quite important. But we also have some other aspects which are also extremely important, because in Poland 20 years ago we had quite similar work as DPO, as data protection officer. It was in Polish Administrator Bezpieczeństwa Informacji, ABI, and in the past the tasks of such people were completely different, because they were responsible for information security, and now they are not responsible. We think about data controller as a person who is responsible, and we think about DPOs as people who help, who give some tips, some recommendations, I would say, but they are not responsible for personal data protection. They don't take the most important decisions. Data controllers must do it on their own. Okay, let's talk about tasks. So first of all, DPOs are responsible for informing and advising the organization. So all the people, all the employees can join DPOs offices, rooms maybe, and they can, or just email addresses, and they can just ask them about everything which is connected with processing personal data, if they do not understand some legal provisions, if they, for example, don't understand some internal procedures, they don't know what to do, or they are not sure if they can, for example, change the places of the furniture in their offices. They don't, they are not sure if they can start doing, for example, a competition to advertise their products. They can ask DPOs, and they can tell them what they think. They do not decide whether they can do it or not, because this is the decision of the head of the institution or a company, but they have to give them their opinion. Also monitoring compliance, of course, and advising on data protection impact assessments. It means that if we take DPIA, they have to again, they have to tell what is their opinion, what would they do, but they do not decide what to do. Also, one of the tasks is also cooperating with the supervisory authority, which means that they have to ask the questions, they have to for example, create reports if they ask about it. It is not very popular, so our authority, supervisory authority, doesn't ask DPOs for many things, but maybe in the future the situation will be changed. Would it be possible to access this presentation? Of course, yes, but at the end of the lecture, I will give you my email address. If you contact me, I will just send it to you, no problem. So if you need the presentation, just send me an email, and I will do it today after I will send it to you. today, no problem. Okay, so now we know what are the rules of appointing DPOs, what are the tasks of DPOs, and for the last few minutes of our lecture, let's think about future priorities. So GDPR is something special because it is not connected with Poland or in one different country of the European Union. It is connected with all European Union countries. It means that if we travel between Poland and France and Spain and Czech Republic and Hungary and Lithuania, etc., all the European Union countries, we have the same legal provisions connected with personal data protection, which is something important. Of course, sometimes we understand some provisions in a different way in different countries, but there are, but in the European Union level, we are trying to do it quite the same. So what are the future priorities? First of all, we are talking about clarifying the DPO's role and status. It means that some legal provisions connected with DPOs are not very clear, and we are not sure what to do if we think about, for example, the conflict of interests of some other aspects. It means that we are not sure if such person can be DPO in our organization or cannot, and we need some special procedures. And if we work on it in the European Union level, and I've heard that on February, I think next year, we'll have the special procedure what to do with DPOs and what is the role of DPOs. It will be really helpful, and it will help also to avoid differences in all the European Union countries. What's more, enhancing consistency in the implementation of DPO obligations. Of course, it's not still so clear. We understand general rules that I showed you, but we have to think about some specific rules, and also providing further guidance via the European Data Protection Board. I think that of course, it is connected with politics. Sometimes we have some different troubles in the European Union, as you know, this time connected with yeah, this is the topic for other lectures, but we think about military aspects of European Union nowadays, and we do it more often than thinking about GDPR. But I think that European Data Protection Board is a very important institution for our future, because we can create some special procedures. We can cooperate, we can share our experiences connected with personal data protection. I think that for example, if we can talk, I think about Polish supervisory authority, talk and share, compare and contrast some actions taken in other European Union countries, and see how they manage to avoid many problems and difficult situations. We can just learn how to do it, and we can share such experiences. But sometimes we have to wait a few years, because nowadays in European Union, I think we'll talk about different aspects of our everyday life. So I think just to sum up, we have 7 years experiences, and we can say that It was a really great challenge to build a common system of personal data protection. In my opinion, we haven't finished yet, but we have. We are in the middle part of this process. I think that we have a lot to do, but let's think about such 7 years as a good 7 years of personal data protection. We learned a lot also from each other, from different European Union countries, and I think that if we try to predict the future, the personal data protection will become more and more important. Also, if we check some plans of changing, creating different legal acts in European Union levels, if we think about artificial intelligence, if we think about copyright in also many different aspects. One of the aspect is connected with AI, but we have many different challenges. And if we think about GDPR, I think that in maybe 2-3 years in the future, we can think about making some changes, maybe to make this law a little bit better in some aspects, but not now. I think that now we have 7 years experiences. When we will think about 10 years of experiences, it will be a good time to think about it. And this is all. Thanks a lot. If you have any questions, you can ask them now. Feel free. You can use the chat on the right down corner. You can also just let me know if you would like to turn on the camera and your microphone. And if you don't want to ask the questions now, but you think about some questions in the future, you can also find my email address here. Feel free to contact me. With some of the participants we know very well, we know each other and we cooperate, but maybe there are some participants who would like to start the cooperation, so feel free to do it. Thanks a lot. Okay, there is a question. Okay, so please write down the question. I will just open the window because we have very cold May in Poland this year, but inside it became very hot. Okay, so first of all, I will answer the question connected with technical aspects. If there are any form of attendance we have to mark for this seminar. No, if you just fulfill the form, it means that you are here and you will just get the certificate by to your email address next week. So you don't have to do anything else. You just wait for the certificate and we will send it next week. If you don't get the certificate next week, just contact our IT department or me. This is my email address. But I hope that everything will work. Okay, the next question, you mentioned that data protection officers must be designed in public institutions. Do you think that in the future designating DPOs will also become mandatory for private companies? I think that Well, maybe in the future, but maybe in 10 or 15 years. It's impossible, in my opinion, in, for example, 1 year or 2 years' time, because of the fact that, as I told you during the lecture, in 2018, we had many troubles to find so many people who are experienced and well prepared to be DPOs in public institutions. It would be very difficult to find so many people also for companies. Maybe, I'm not sure, but maybe in a few years' time, we'll think about such new legal provisions that it will be obligatory, for example, in the largest companies, if they employ, for example, more than 500 employees, and maybe that's the speculation. Okay, yeah, next week certificates. What do you think about which level of privacy should central bank digital currency enjoy in EU? Well, in my opinion, the regulations of the GDPR are really appropriate, and when we think about the risk assessment. So if we think about central bank digital currency, we just have to see the risk assessment. They should do the very clear and very professional risk assessment, and then we can decide about the level of privacy. So it's up to risk assessment, but I'm sure that the level will be high because of the kind of data and importance of such institution. You're welcome. Okay, I can't see more questions. So thanks a lot for the fact that you attended this lecture. Again, I would like to invite you to the website wsei.pl. We have many different international events in English language. Please join us and feel invited to actions that we take. Thanks a lot. Yeah, thank you. I'm waiting just to check if maybe someone is writing. I'll write the website out. Okay, the website is very easy. If you join the website, you can just change the language on the right top corner for English, and you have all the pieces of information in English. Thanks a lot. Okay, all the people just write thank you, no more questions. So again, thanks a lot. It was nice to meet you today, and see you next time. Bye-bye.